Mr. Nielsen, good morning.
Good morning. May it please the Court, my name is Mark Nielsen, and I am here on behalf of the agency defendants and more broadly the administration to address the important issues of administrative law raised by this case. The Commissioner of the Division of Occupational Safety is statutorily charged with administering the prevailing wage law, and his determinations are therefore entitled to a degree of deference on review. The law states broadly that mechanics, apprentices, teamsters, chauffeurs, and laborers shall be paid the administratively determined prevailing rate when they are engaged in the construction of public works. The narrow question at the heart of this case is whether teamsters hauling and installing bituminous concrete at a public job site should receive the prevailing rate during that portion of the day when they are hauling away from the job site. They do receive the prevailing rate when they are at the job site installing.
Out of curiosity, what's the difference between the prevailing rate and the rate they would receive if they don't get the prevailing rate?
Justice Graney, it changes all the time, of course. I'm told that the prevailing rate for the installation work is about $38 and that the difference would be about $10 an hour. So again, they do receive the prevailing rate when they are at the job site installing. That's the agency decision affirmed in the 1989 Construction Industries of Massachusetts case, the so-called SIM case. Here, the focus is on the other part of the Teamsters work, the off-site hauling work. The Commission held a public hearing, considered extensive comments, and in a careful 10-page decision, ruled that they should not receive the prevailing rate for the hauling time. That interpretive ruling was fair and reasonable and entitled to deference. The Superior Court afforded no deference, disagreed with the fairness of the agency's ruling, and substituted its own judgment.
Do you think it's fair? Is it fair?
Yes, Your Honor. I do believe that it's fair, and I would give the following reason. Fairness has to do with treating similarly situated persons similarly. It would be unfair if, by virtue of a small amount of installation work, someone who was involved primarily or predominantly with hauling received the higher rate for the entire day, receiving an overall much greater pay than a hauler who never actually entered the job site. And so I think when we think about fairness in terms of treating similarly situated people the same, that the Commissioner's ruling is a fair one.
Are there any other circumstances where an employee who is working in connection with the job gets paid the prevailing rate only while physically on site, even though what they may be doing off site is related to the job?
Yes, Your Honor. Yes, Justice Cordy. And in fact, the decision, if you look at it, the 10-page decision makes reference to two examples. A carpenter who is making cabinetry off site, when he arrives at the site and installs the cabinetry into the public work, receives the prevailing rate during that portion of the day when he's doing his installation work, but does not receive the prevailing rate during the portion of time when he's away from the job site fabricating the cabinetry.
But would that be a carpenter who was a subcontractor, or let's assume the carpenter was an employee of the general contractor and spent 6 hours a day in the carpentry shop building the cabinets, and then 2 hours a day installing what he had built? Would only be 2 hours a day that he'd get the prevailing rate?
Only 2 hours a day. And the applicability of the prevailing rate law assumes that he's an employee. It's not critical whether he's an employee of the general contractor or a subcontractor. What's critical is that he's an employee, and yes, he receives the prevailing rate during that portion of the day when he is installing on the job, but not otherwise. A second example also mentioned in the agency decision is a wrought iron worker, someone who fabricates perhaps a light post for a highway at a facility off-site. When he's doing that work, He does not receive the prevailing wage rate. He is not protected by the law, but when he comes onto the site, changes his hat, so to speak, performs a different task, during that portion of the day, he is entitled to the prevailing rate.
And these two examples are examples that actually come from rulings of the...
Come from this precise ruling. These are cited in this precise ruling at page 56 of the record.
No, but I know they're cited and are briefly discussed, but are they specific rulings that have previously been made by the Department of Labor?
Yes, they are, Your Honor.
I take it, Mr. Nielsen, that what the Superior Court judge was doing was essentially trying to interpret our decision in the construction industries case, correct?
I believe that's right, Your Honor.
And I take it that what we were doing in that case was upholding an agency determination.
Yes, I think that it's very important to look at SIM and understand that it was, as you say, upholding an agency determination, determining that the agency had the authority to come to the conclusion that it did on the debatable question that it faced. The policy at issue in this case is a refinement of the policy affirmed in the SIM case, and it focuses, as Justice Cordy was pointing out, on the somewhat unusual instance where the worker at issue is doing one task during part of the day and a different task during the other part of the day.
As far as I can see, there's nothing in SIMS that really controls this case.
I think that's exactly right, Your Honor, other than the deferential standard.
Let me ask the question in a slightly different way. Is what's involved here a change in definition or interpretation of a statutory term, or are we involved with administrative action that has taken place within a pre-existing range of possibilities?
I think the latter, Your Honor, that this is an agency decision that interprets the statute, applies it to a factual setting, and it makes a refinement in policy. It explicitly points out that some workers do certain tasks during one part of the day and switch to a different task during the other part of the day. Given the nature of the work involved, one of the tasks may be entitled to prevailing rate, those tasks that are on-site and involve installation, while the other task, which is off-site and involves hauling, is not entitled to the prevailing rate.
If we affirm the Superior Court judge, will this have effect will this affect other workers as precedent? Will other people be affected besides the immediate ones in this industry?
I think, Your Honor, that it simply deals with this particular job classification, but it will set a damaging precedent in terms of what the leeway of the commissioner is to administer the statute.
Thank you, Mr. Nielsen.
Thank you.
Mr. O'Reilly?
May it please the Court, my name is John J. O'Reilly III. I represent the private employers and contractor associations.
I take it be your view that the commissioner, or director, I think his name is, deputy director, could change, as a matter of policy, this degeneris or degenis policy, which he could change that. He had authority to change that.
I think that's very clear under the decisions of this Court that subsequent to SIM, that a outgoing commissioner, literally on his last day of office, issued a memorandum without a hearing notice to anyone saying that these drivers were covered for the over-the-road activity under his interpretation of the SIM case. No one really paid much attention to the degenis, as is noted in the hearing, in the record. A number of the enforcement agency, the Attorney General's office, as reflected in last year's LaRusso case, was enforcing only against job site hours under its interpretation of the SIM case. Of course, this agency has now adopted that same determination. There was a decision by Judge Sprague in the Concord District Court saying that only the job site hours are covered. And then, of course, last year in the LaRusso case, the Court of Appeals determined that the Attorney General was perfectly proper in only enforcing the statute against the job site hours as opposed to the over-the-road driving hours.
But would that have been a perfectly permissible policy under the statute, the DeGenis, however it's pronounced?
DeGenis adopted that policy.
Is it permissible under the statute?
I would say it is not permissible. It is not a proper interpretation either of the statute or of this Court's interpretation application of the statute under SIM. This Court, I thought, used very clear language, almost identical to language used in the Circuit Court of Appeals Midway decision, where it said the statute's very clear. It talks about job site activity.
Let me ask you a related question. As you know, there's a lot of briefing about the concrete mix drivers. You're aware of that?
I'm aware of that, Your Honor, yes.
But that issue is really not before us.
I don't speak for the concrete.
Well, I know.
I tend to agree with you, Your Honor.
I was going to solicit your view on whether we should decide it. Ordinarily, we don't decide issues that are not before us or raised just by amici. On the other hand, it looks like one that's surely going to come here. Perhaps the answer is we should get directly related parties to brief it when it gets here.
If I could just make one brief comment in connection with that, Justice Greene, the only time Ready Mix has ever come up was under the same DeGenis. We stipulated, when I argued the SIM case 20 years ago, we stipulated that Ready Mix was not covered under the statute. That was the stipulation before the Court. DeGenis took it upon himself to throw in Ready Mix.
But if we agree with you today and uphold the deputy director, we'd have a situation where the asphalt drivers get one sort of thing and the cement people get, under the policy, get a different situation.
Well, as I say, the Ready Mix only came up under the DeGenis, and the decision that's before, the administrative agency decision that's before you today,
I know it, but
rescinds DeGenis.
Well, I know that, but my question is, we'd have two different pay rates, would we not, if we go with you?
Well, you always have different pay rates. The asphalt drivers are under one agreement in the context of a union.
But the ready mix would get paid for driving to and from the job site if we, notwithstanding, no?
No, because then the administrative agency decision that's before you has rescinded DeGenis.
Oh, fine.
Yeah. I want to make sure I understand your position. I take it that you come to the same bottom line as Mr. Nielsen does, but for different reasons. He seems to be saying that, look, it's a matter of policy that can be changed one way or the other. And I think I understand you to be saying that the prior policy, the DeGenis policy, is flat not permitted under the statute.
Well, that would be our position. If DeGenis took the if that were the current lay of the land and they were enforcing the DeGenis, which no one really was, but if they were enforcing it, I'd be before you today or sometime in the same position as the plaintiffs were in the Midway decision, saying the statute is very clear. And this Court made it very clear in the prior SIM decision that we should be talking about job site activities only. And it's a twofold test. Number one, it has to be a job site activity. And number two, it has to be an activity that is related to the construction itself. The UPS driver who's a Teamster comes on the job, but he's on the job, but that's not enough. It has to be on-job activity that is related to the construction. That's the twofold test that SIM set
But the Department of Labor, I take it you're saying, the Department of Labor could not conclude that getting to the job site activity with the equipment that you need to work at the job site could never be included in this wage scale.
That's exactly what our position would be, Your Honor. That was the position of the U.S. Department of Labor in the Midway case, and that was litigated up to the Circuit Court of Appeals, and the Court said, no, the statute does not allow an agency to talk about off-site activity. And that would be our position. Our position, of course, is a little different today. We're saying that the agency, because the agency ruled the way it did, there was a perfectly permissible determination, and Judge Riley substituted his judgment.
Well, let me ask you this. If one of these drivers is involved in an accident on the way to one of these, he's got a truckload of this material and is bringing it to the accident, and it comes to, and is injured and is eligible for workers' comp, do they set the workers' comp rate at the over-the-road rate or at the job site rate?
I don't purport to be an expert, Justice Spinner, in workers' comp. I would assume it would be based on the rate of driving.
Well, I take it that one interpretation would be it depends where the accident is. If the accident is on site,
Well, if the accident's on-site, clearly it's an on-site activity, and he's being paid the on-site rate. But if I see my time is about to expire, if I may just make one suggestion to the court. It seems far less practical and less reasonable for a determination to be made that a driver who, under the sim case, spends some 5 to 15 minutes on the job, for his entire day to be triggered into or funneled into a job site higher construction rate activity, as opposed to the bricklayer, as the example I use in my brief. He spends 8 to 10 hours on the job. He is paid for the construction work that he's performing on the job. But if he goes before the job to a hardware store to pick up, or a supply store to pick up brick, mortar, and so forth, throw them in the back of his pickup truck, and he travels the same highway that this asphalt driver who spends 5 or 10 minutes on the job, he doesn't get paid the job site rate for those hours, and it just doesn't make sense for someone who spends 5 to 15 minutes on the job to get paid for the entire day at the higher posted wage rate.
Thank you,
I appreciate
Mr.
your time.
O'Reilly.
Thank you.
Mr. Kelly?
Morning, Your Honor. May it please the Court. My name is Paul Kelly. I represent the appellees here. There are 9 local unions and 2 sort of umbrella unions who have joined together. They have a common interest in enforcing the prevailing wage law. As labor organizations, they also have a common interest in eliminating competition among workers over wages. In the prevailing wage law in Massachusetts, the legislature adopted a policy that on public works, we ought not to be competing over the rate of wages we pay our workers. So we have prevailing wage law, which allows the contractors to compete on the basis of whatever efficiencies and that they can muster, but not because they pay their workers less than the other bidder. That's the purpose of the law. And we think the purpose of the law coincides with the reason that these labor organizations exist.
Well, what do you make of apparently other rulings which suggest that, leaving aside asphalt truck drivers, other people who work on the job don't get paid for job-related activities that are off-site?
I hear that, Your Honor. I think, respectfully, I think it's an uncommon situation.
What about carpenters, Mr. Kelly?
I'm sorry?
What about carpenters?
I think that's an uncommon situation as well, Your Honor, because I don't think carpenters, shop carpenters who fabricate the finished cabinetry, if you want, do it in the shop and then say, okay, I'm going off to the job to install it.
What about steel fabricators who bring in, obviously on trucks, bring in the steel skeleton of the building? They would be covered by, if your position goes through, the same thing, would they not?
Well, if we're talking about the iron, Your Honor.
Iron workers.
The iron workers. The iron workers are on the job. The steel comes on a truck, and it is installed on the job. And the
What about the truckers that bring it in?
Well, it is true that the truckers who deliver the iron are not covered. That's true. And that's the question. That's the question that.
Well, wouldn't they want the same rate of pay for bringing it in?
I'm sure they would, Your Honor. If they're lucky enough to belong to a collective bargaining agreement, they'll get it.
But the truckers who bring the steel in or the iron in, they don't do anything with the iron at the site, do they?
No,
they just drop it off.
That's the point. That's precisely the point. And in 1986, when the commissioner said, I'm taking these asphalt companies to court, because back in 1986, the only way to enforce the prevailing wage law was through a very awkward, cumbersome, and as Judge Nolan said, rarely enforced criminal proceeding. That's what happened. And the question was, well, are these drivers covered? And the answer was, what do they do at the site? That was the answer. What do they do at the site? And do they do something at the site? And the answer was, yes, they do. They work with the job site crew to spread and lay the asphalt. So they were covered. That was the answer. But it was not, it seems to me, it is not an acceptable reading of that case to say they were only covered for the minutes or hours that they were physically on the site.
Mr. Kelly, at least from where I'm sitting, to pick up on an earlier comment of Justice Glaney's, I don't think that construction industries helps me at all. In other words, what was before the court was on-site. So you either have to go to the statute and tell me how I should read the statute, to the Dengenis ruling, the commissioner's interpretation, because whatever language may be in construction industries, it wasn't talking about what was happening off-site. So essentially what it was saying was, how do I look at whether or not people who are on-site to determine whether or not they paid? So to take Justice Glaney's, if it's a steel manufacturer versus the steel, whether the people who are actually installing the girders, how do I look at that? But it doesn't help me with respect to the off-site, the coming backwards and forwards.
Well, except that it was clear that the job they were performing included that. Justice Nolan, since at least 1976, the commissioner has considered those truckers who haul bituminous concrete, who haul it to the site of the public works project, and who aid in the application of that concrete to be Teamsters employed on those sites. That's those people who haul it and who aid it are Teamsters employed on those sites.
But
Now, let me just say something
doesn't
about-
the statute, doesn't the wording of the statute permit either interpretation? Doesn't it permit enough discretion for the administrative agency to decide one governor could decide it one way, another governor could decide it the other way?
Well,
Mr. Kelly, let me just go back if I can. Justice Nolan's decision, which I have here, since 1976, right, and so we're now talking about whatever date it was, 1989. And don't forget, this is the Commission's interpretation that has been challenged by the employers, right? And he says since then they have been, the people who haul and aid in the application of the concrete. What was how had the Commission been determining the extent of the prevailing wage since 1976 for the hours in the hauling?
well, I think the answer is, Your Honor, all the commissioner did was post the hours. There was in other words, the commissioner issued the rate. It's whatever it is,
Yes, but
$30, $25.
do we have anything from the record, which I couldn't find, as to how you calculated the hours? In other words, because I take it that Justice, one way to look at Justice Nolan's decision is to say the issue as to whether these particular people were covered as Teamsters under the statute was because there had been a suggestion that because they were hauling, once they hit the site, they were not covered, right? And he was saying the fact that they haul on, it's because they also are working on the site. That's what I'm looking at. But I don't have anything that suggests that at that time that the prevailing wage was being paid for however many hours they were off the site.
Well, I think as a practical matter, the commissioner considered back then, the commissioner considered the drivers to be covered for all hours. I think
But how do I know that?
only
in other words,
because that's what it said. I believe that's what was stipulated before the court back then, Your Honor, that the commissioner considered these people to be Teamsters and to be covered. And this issue of
No, I understand that they were covered, but were they covered for on-site hours? Let me put it this way. One of the issues that's raised is how do you track the hours, correct? In other words, it's perfectly easy to track hours of workers arriving onto the site. How do you track hours for workers when they're off-site. And so as I looked very carefully at that case, I couldn't see, I understood that once they hit the site, even though they are haulers, I think no question they were haulers, but once they were hit the site, they were covered. There's nothing that's from the case that suggests to me that any time prior to that. And it's important to me for this reason. There is a rule of statutory construction that says, if you take Justice Spina's point, maybe the Commission has some discretion, but if for 30, 40 years, 30 years at least, the system has been working so that the off-site hours are covered, then if a new commissioner comes in and says, I'm going to change it, all of the expectations are different. But if they've never been paid for the off-site hours,
This off-site hours business, Your Honor, I think respectfully shows up only because of the Midway decision in 1991. Before that, see what happened, this law, and this law is a little different. This law was enacted originally, it was a citizen's preference law, and it was a prevailing wage law. It was enacted in 1896. In 1935, Section 27 and 27A, which involved the commissioner and his administrative duties and so forth, were put in place. Teamsters were part of this statute before 1935. In fact, in 1935, they added the word chauffeurs, which I think means the people who drive trucks compared to the people who would tend the horses and the teams and so forth that would be engaged. So Teamsters have been part of this statute. Teamsters are not part of the Davis-Bacon prevailing wage law. That says mechanics and laborers. And it also says directly on the site. In 1941, and this is the Midway case, in 1941, the Secretary of Labor issued a regulation under the Davis-Bacon Act. And it said that it didn't say exactly these words, didn't use the word material men, but it essentially said material men are covered. So the steel delivery truck was covered under the regulation. What Midway did in 1991 was it reviewed that 1941 regulation. And I submit, frankly, that that's an example that this agency ought to follow.
Mr. Kelly, let me ask you this. It's a point that Mr. O'Reilly brought up. Is it fair and reasonable to pay a driver who might be at a site for only 10 or 15 minutes for the entire day at a higher rate? Is that fair?
Is it fair? You mean, is it fair, for example, a driver
who drops off some stuff, he's at the site for 10 or 15 minutes, he leaves. Now, under your position, he's going to be paid at the prevailing rate, isn't he?
Your Honor, he is.
And is that fair?
Well,
he's there 15 minutes.
I believe the question is, did the legislature determine that that's what ought to happen? And I think the answer to that is yes. And whether I agree that there's limits to what's fair from the legislature's point of view. They can say, and if you read read the Midway case, there was discussion over the steel, I think. Representative LaGuardia from New York was one of the proponents, and the question was, well, do we have to set the prevailing rate for the people who fabricate the steel for the building? And they said, no, we're not going to do that. Directly on the site of the work is what.
How do we read that?
The legislature, how do you respond to the argument that the statute expressly covers driving time for gravel and fill haulers?
Correct.
Suggesting that for whatever reason, the legislature has carved out one particular trade that is to receive the prevailing wage for during their driving time. Doesn't that suggest that other trades do not receive the prevailing rate for the time spent driving, transporting, et cetera, only, for some reason, gravel and fill haulers?
There certainly is that argument, and that was the argument, I think, that was being made in 1989. I think the argument was that material men are not covered. The steel delivery truck is not covered, and the example you just gave, Your Honor, was the example. A gravel or fill material man. Somebody who delivers and removes gravel and fill could be said to be a material man just as easily as the fellow who delivers steel. They are covered specifically, but other material men are not.
But doesn't the statute also expressly cover their driving time? It doesn't just make them, quote, covered under the statute, but says they're covered, including the time that they spend in transporting the gravel and fill.
Correct.
And that seems to be what's missing from the statute as to any other trade where it involves the combination of bringing material to the site and working with it on site.
Well, I guess if we go as far as we can go with that, Your Honor, except for those fellows who are expressly covered by the 1973 amendment, I think Teamsters are effectively written out of this statute, if you follow this this analogy. There is no coverage of Teamsters if it's only the time you spent on the site that gets you the prevailing rate.
Why is that? Because they spend so little time at the site?
Well, because what they do is they operate vehicles, and typically the operation of those vehicles is off-site.
Well, but Teamsters operate a lot of equipment on site too, unless I've forgotten my construction experience. It seemed that everybody that operated a machine was Teamster. All day.
The operating engineers might challenge you on that one, Your
Oh,
Honor.
all right. Well,
Mr. Kelly, let me ask you this. Is there any reason why a particular driver or, series of drivers, if they are delivering to a public site, cannot on the same day deliver to private sites?
That is certainly possible. I think it's more. It happens more often, Your Honor, frankly, in the ready-mix concrete, I think, than in the asphalt. I mean, asphalt, public roads are largely public, and I suppose there is some asphalt work that are on private jobs, but
Well, I was thinking of, and this is purely hypothetical, but you have a town that's got a couple of potholes, but you've got a big new residential development going on, all of which is private. And
the roads aren't private, I wouldn't think.
well,
But they are at the beginning.
They are at the
They are
beginning.
until they're made.
They are at the beginning, as somebody's laying out plot plans and subdivisions and so on
Or
and so
parking
forth.
lots?
Right,
Big parking
right. Well, it's true that the work involved in the private, if it's even in the same day as work on the public, would not be covered by the prevailing wage law. That's correct.
Mr. Kelly, in answer to Justice Ireland's question about whether someone who spends 15 minutes at the site should be covered by the prevailing wage for the entire day, you said the answer would be look at the legislative policy, the legislative intent.
Right.
But then, as Justice Dawson pointed out, as far as we can tell from the legislative intent, the legislature intended just one particular segment of workers to be covered by the prevailing wage. So I don't see how you answer Justice Ireland's question, legislative intent, and then when legislative intent looks like they intended only to cover by the prevailing wage that one segment that they've named in the statute.
Justice Sossman's example, Your Honor, I believe, was that there is one class of material men which are covered, and those are the dump truck with the gravel and fill. Other classes of workers are clearly covered by the statute. One of the classes is Teamsters. And the question with respect to the Teamster as to whether he's covered with respect to his duties in connection with that project, the test is, what does he do on the site? And if he performs work on the site in conjunction with the other workers, then he is covered. That's what the Sim case said. And so Teamsters, who have a substantial nexus to the site, are covered.
Mr. Kelly, could I ask you one other question? I'm looking at the agency decision, and there's a part of the decision that talks about a statement of facts and then goes on to describe the testimony of Mr. O'Reilly about the drivers typically, and this is what the statement of facts is, typically travel to public and non-public construction sites during the day. Now, am I bound? I mean, have you challenged
Your Honor, one of my problems from the beginning
Yep.
was the nature of this proceeding. 27A says you can appeal a wage determination or a job classification. There's a very limited review, certiorari, arbitrary, capricious, all of that. It's because it's a ministerial act. What these people did was got together and held a kangaroo court. Mr. O'Reilly files a 27A appeal of nothing. He just wants to change the law. And the department says, okay, come on in. They have this, what they call a hearing, where they brought everybody into a room. Mr. O'Reilly gave his testimony.
Did they give notice to your clients?
They gave notice to lots of people.
To everybody?
Yes.
And
yes.
so did you have an opportunity to present evidence?
It was not evidence. It was making speeches, Your Honor. There was no evidence. It was making speeches, and then they went back and they wrote the decision and they changed the law. I mean, they have the right to adopt regulations. If they want to do this and they have the authority to do it, they ought to do it in accordance with the Administrative Procedure Act, in my humble opinion.
So you do agree that they could change the law in the manner that has been changed?
Your Honor, frankly, I think the statute on its face is ambiguous. It seems to me that Judge Nolan took that out of play when he said it isn't. And so I would rest on the interpretation of the statute that the SJC put on it, and leave it at that. And if they want to change the law, they can go back to the legislature and they can do it. And frankly, they've been trying to, and they weren't successful. And so we get this 27A appeal as a.
I take it, Mr. Kelly, the answer to this question is going to be no. But is there anywhere in the record that I can determine whether Teamsters who were hauling to and from the construction sites prior to the SIM decision were being paid prevailing wages until it was challenged by the particular employers who challenged it? Prevailing wages for the off-site hauling. There's nowhere that I can tell.
That was what the commissioner was enforcing back then, Your Honor. That's all I can say. I assume people were doing it. The people who were doing it were not prosecuted for not doing it. And these people who said you can't do it challenged it, and that's how we got SIM. So I don't think the record specifically finds that other asphalt companies were paying the prevailing rate, but that's what the commissioner was doing from 1976 until.
Well, we are fortunate that we have counsel who were arguing the case in 1989, and they're back here today arguing the case today, and I still don't have the facts. But I'll go dig
over
back
the road.
Thank you, Mr. Kelly. Thank you.